So my name is Linn Sørensen. I'm writing my PhD dissertation at the Faculty of Law here at the University of Oslo, where I'm looking into multinational corporate group structures and how EU legislation are understanding corporate groups and their information and their disclosure obligations. Before I look into the first question of what kind of degree of transparency or disclosure is ensured by law, I will start off with one of the questions posed here earlier on, which is quite important for you as journalists. I would say that we all have our particular role in the society. We all have our mandate. For me as a researcher, I look into maybe the differences in areas of laws, where they are matching and where there are mismatches. For you as journalists, you look into, and investigative journalists, you look into the facts, trying to explain to the public how businesses, how these actors are operating. And I would say that it's not necessarily the question of whether being lawful or unlawful the activities that you are looking into. Because as a lawyer, I would say, and there are people here in the audience which would agree with me, that the answer to that question, whether it's a lawful or unlawful activity you're looking into, is not necessarily decided before the Supreme Court, in the final instance, have made their decision. So many of the issues that you will come across when you look into financial flows, they don't necessarily have a clear answer whether it's legal or not. And this brings me to my wish for you as investigative journalists. I hope that you in the future will then pose and ask the consequential questions, which means that when you're looking into a case, try to not only look into whether we can pin this CEO to the mast and say that this CEO lost his job and it was because of my story. That's interesting maybe for a day, a week, a month. Doesn't change the world, doesn't change our society. What changes is if you can explain to the public how these people are operating and what it actually does to the corporate environment, which may, for example, be that huge tax planning can only be done by the biggest corporations, meaning making very bad degree of competition, which again would influence employment, etc. Crucial issues for our society. So with that, I will start by looking into the corporate disclosure obligations. When you look into, and we'll talk about the corporate groups, not necessarily only the individuals behind it. When you look into corporate groups, as you can see on this map, all of the dots will represent companies. This is not necessarily a very complex structure. Is actually what you will find in many corporations if you try to look into them. And what I will illustrate here is that when you do investigative journalism, and when I do research, and when we try to also pose the legal questions, very often we're only faced with the part of the structure inside the circle. And the reason for that is we can divide it into several reasons why it's like this. For once, it can be structural reasons. For example, accounting standards, as I will come into later on, they can say that corporations only need to disclose a certain amount of the group. Very often, the financial statements, like the IFRS, the International Financial Reporting Standards, which is all listed companies has to report in accordance with, they state that the companies themselves are under an obligation to disclose those legal entities part of their group which they control. But it's the corporations themselves who decide or do the assessment of which entities they control. This means that there can be a massive amount of corporations outside the structure that you're looking into, where there may be crucial information based on contractual ties and not necessarily only by the legal concept of control. Some of you as journalists has also said that you can also find not only the nominee accounts that you're not finding a direct link, but there can be, as was posted an example yesterday, it can be also based on a person having a gun to his head who is signing the corporate documents. There are many reasons for why you cannot find a direct link between what is going on in the corporate structure you're investigating and maybe where the crucial information lies around the circle. Another reason for why we're looking into the scope of this circle can also be like for transactional reasons. It's what kind of information is relevant for this case, or what we think is relevant for this case. Again, where the material information may rest outside. And as the ones you heard me talk yesterday, one of the reasons for making why disclosure can be a huge issue is also that our legislation as it is today is very much based on how business reality was in the 20th century. Whereas now in the 21st century business has changed dramatically. So this means that a lot of our legal concepts, they're not necessarily fitting anymore. So for example, tech companies often use as examples that we cannot tax them, we cannot hold them accountable. And the reason, I would say, is not only the tech companies, is more and more businesses they're operating with ownership structures not necessarily directly covered by the law. To give you one example, which I also will return to, is the concept of ownership, the concept of control, beneficial owners, as many of you are looking into as investigative journalists. The concept of beneficial owners is not necessarily the same thing if you're looking into a money laundering case or if you look into a tax case. In the money laundering cases, we're looking into the ultimate beneficial owner as a physical person, someone who is actually gaining any benefit by the end of the day. So it's only when you cannot identify any physical person that you can then address the company and you will take one of the leading board member of the company. But for tax purposes, and there's a reason why OECD has not maybe found a consensus of this concept for over 40 years, the consensus is more a company that is able to spend or have any sort of benefit of the money sent to it. But this is not necessarily the ultimate beneficial owner, and definitely not the physical person that you are trying to address. So based on this, only a part of the structure is covered by disclosure, or what they need to disclose. Oh, it's a little bit weak. Again, when we come to what do companies have to disclose, there are several different paths, different types of data that the corporation had to disclose on. First, of course, you have to distinguish between the public, the listed companies, and the non-listed companies. For the listed companies, there is a massive amount of reporting obligations because of securities and stock exchanges. It's for tax authorities, financial statements as the IFRS or other accounting standards. Non-financial reporting in the EU now, it's been a massive mobilization on having more and more reporting on environmental and social footprints and corporate governance and control structures. So the law is ensuring that corporations provide information, public information, sometimes not public information, but only for tax authorities, for example, about their activities. So what is crucial to understand with the law is that it's only a tool for transparency. It's absolutely not the end of means. I often use this picture. It's a fantastic picture of from nature. And it's, I would say that when we talk about disclosure of information of corporations, sometimes we can look at this as all of the amount of information which is provided, and the tip of the iceberg is what we use. The information that we understand with all of the massive information that we gain, but we're not looking into the whole picture. It can also be a representation of the actual information that companies provide, which may be the tip of the iceberg, whereas the material information may rest still underneath the surface. For example, all of you engaged in the discussion about secrecy jurisdictions. And what we know is that secrecy jurisdictions, they have very limited legislation where they gain or secure information from corporations, meaning that we don't have the data necessary to actually understand who is the actual beneficial or the owners of this information, this company. For those of you who have heard me talk before, you would know that I'm very into the situation of the costs of all of this information. For corporations, it's a heavily cost for them to provide all of this information for companies, no, for the society. And for the assessors, it's information costs related to actually processing the information. And all of these costs in society have pushed, when we look at the international arena, has pushed for, on the one hand, larger enterprises. We are moving into a new area of conglomeratization, where companies are getting more and more interconnected. But it also has created a situation where companies are looking into new ways of structuring their businesses. And as one example, for example, using now new technology, using a blockchain to control other entities instead of only the traditional shareholding relation, will leave you outside the scope of a lot of today's legislations. And again, the concept of bounded rationality and how each and every one of us is able to understand the information you have in front of you is getting also more and more limited due to this complexity. So what is complexity about? I will say that for today I will use say that it's based on 4 different levels or degrees that you should look into when you do investigative journalism on this field. And one is the complexity related to the structure. So structural complexity is not only that you will find different types of entities. You will find limited liability companies, maybe one listed limited liability company, but you will very often find a huge amount of trusts, foundations, and other more contractual forms. The interesting part of these contractual forms is that they are not always covered by legislation, so you will have to find them through contractual ties more than what you can rest on if you only look at the financial statements. Another important thing to understand when you look into the structure is the differences of what I call subsidiary typology. Some subsidiaries would be operational. They will be the ones actually doing the mining or being actively engaged in the corporate activity which is done. Others are holdings or special purpose entities, companies. It's just holding maybe they're the owners of a building in the structure, holding onto the shares of another company. They can be shell entities where there's absolutely nothing, no economic activity going on at all. Or they can be service companies where the primary purpose of the entity is just to fulfill services of the rest of the group. The importance here is that also, as Craig was touched into, these, if you do have like invoices going on to shell companies where there is no activity, that's a red flag for sure. So you need to look into what type of company is this representing the group structure. So for shell companies where there are no economic activities, or companies which are registered in tax havens, they will, to some legislation, for example, the country-by-country reporting, as probably what you pay is also interested in, they will maybe be left outside of the reporting. So again, some companies related to the structure you will only find through contractual means and not necessarily through ownership structures identified in financial statements or corporate governance statements. The second level of the complexity, the corporate complexity, as I would suggest that you would look into, is that if we think aside the forms that you can have based on contracts, the trust, for example, the relation between corporate entities in a group structure is primarily based on shares. So you will primarily be interested in who is owning or controlling the shares in the company. However, in the late 1980s, what we call like when we had this massive amount of deregulation in finance, we ended up in the 1990s with what has been denoted as the derivatives revolution. And what happened was that what we had tried to standardize in terms of law, in terms of corporate law, they started to decouple, disrupt in contract law. So what we used to have as a share, which was the financial instrument, standardized financial instrument, which created some sort of control link between corporate entities, started to be split up onto different components, making sort of a mess when we want to pose the question of who is actually in control. Because the reality today is that we can have, what we used to have, one share. If you buy one share in Statoil, then you have a presumption that you will be able to vote that share at the general meeting. If the company decides to distribute dividends, then you will have a share of that. And you can also suggest topics for the general meeting agenda. However, based on the deregulation of finance, banks and trust and company service providers, they started to create financial instruments where the differences, the different rights related to share, was split up. So for example, instead of me only holding the share with all of the rights connected in Statoil, I can hold only the right to receive a dividend. And one of you could have the right to vote the share. So again, who is then in control of that share, which can be the crucial piece of information when you want to look into who is actually in control of a company. And what we've seen, like the Panama Papers also showed, was that this type of decoupling can be done very easily. It can be done by having another person, a law firm, being the ones voting all of the shares. You're the one also receiving all of the dividends, but outside of all registers, it will only be the person who is voting who will be disclosed. So this leads to a question, who is actually then in control? An example of security decoupling, or these control linkages, where there was no beneficial owner found, was a case in Switzerland a couple of years ago, which is known as the Swiss swap case, which was waited for in the Supreme Court for several years, where actually the security decoupling scheme ended up with finding no one being a beneficial owner of a share and a dividend. So that case was a tax case, and enabled, in order to be covered by a tax agreement, you would have to prove that you were a beneficial owner, but because of this decoupling, the court said, here, there is no beneficial owner. So have that in mind. Decoupling of control rights is disrupting the picture when you're trying to follow the money flows or the people behind it. The third degree of complexity when looking into corporate structure is that the formal reality and what is actually going on may be very, very, very different. Actually, that is the norm. It's more of a curiosity if you find a corporate structure like this, where all of the entities is operating as they should based on corporate law. Because in corporate law, we would say that each and every one of these companies in a corporate structure, they are independent. Corporate law in most countries in the world do not understand a corporate group as one economic entity. Each and every one of these companies, they are mandated by corporate law to make their own decisions based on the interests of the company itself. Where most of you who or either have been involved or looked into corporate structures or will do, will very easily find that that is not the reality for sure. very often we will find centrally steered decision-making structures where corporations here in the lower level, they are the operative entities, but they're basically following instructions coming from a top level, not making any core decisions themselves. But this is actually in breach in many countries with corporate law. And where you place all of these companies and how you do your instructions, in the sense of corporate law, you can only do that as a shareholder at the general meeting, through specialized authorizations, or through shifts of power in the Articles of Association. But very often, it's internal norms which are followed. And when I talk to people working in huge multinationals, they say that the internal norms are very often much more important for them to follow those than maybe also local statutory regimes, because that is just about the amount of the fine that they maybe will get, and that will often be covered by insurance internally in the corporate group anyway. So as long as it's not criminal offenses, it's very often secured by internal insurances. The fourth important complexity part is the temporality. Corporate groups that are changing all the time. So when you're investigating a corporate group structure and what kind of information you're given, which also differs very much in the different countries, much more than what we wish it was, then we have to understand that the corporate group structure, a multinational structure, will seldomly look the same from one year to the next. And this also goes for how we look into disclosure regimes. When in the corporate field, we will say that the competition that kills you never looks like you. It's like this. You're only staring ahead. You're only comparing yourself with what is in front of you. And in my opinion, this is also how we go about when we are amending our laws. We're only looking into what we can see and what we have ahead of us and the issues that we can already know. The problem is this guy coming from behind, which is maybe what has been identified as the tech companies. But let me then remind you, tech companies is no longer as is only Google, Facebook, Apple, which is challenging business reality or how we used to go about how corporations are structuring their businesses. This is much more going on throughout the corporate sphere. And as I said yesterday, if someone would ask how to set up a corporate structure today, I would maybe say that it's much more clever to use control regimes through a blockchain instead of operating in the traditional sphere based on a cost reality. So this is how we have to look about it when we are to amend also our disclosure regulations, and what you guys as investigative journalists should think about, what is actually coming or what do we already have around us in reality, not only focusing on the old-fashioned style of doing business. I will say some few words before my time is up about corporate responsibility and about how to hold corporations accountable. So what is this about? It's about not only financial flows. It's someone was mentioning also the Sustainable Development Goals. It's definitely a lot about the human rights, the environmental degradation, and financial flows. So all of these should be taken into account when we are to look into what these corporations are actually doing. They're not only doing tax, they're doing definitely also, or involved in much more. What we can say is that when it comes to human rights and environmental degradation, the social aspects, there has been also several attempts to try to hold companies more accountable. And this is an aspect of trying where the companies will try to mitigate their risks. So they will do what I will say is risk externalization. They will close different types of risk. If you used to build a car in one company, you establish a lot of different entities in countries where there are lower degree of, for example, chemical regulation. So you can produce things to lower costs, and you can use chemicals that you cannot use, for example, in the EU. So that's a matter of risk externalization. And companies are quite good at that. I used yesterday an example of the H&M who had this factory in Bangladesh who burned. It was not about the legal obligation to compensate the claimants of the family members who lost family members in the fire. It was due to reputational capacity or capital that H&M chose to compensate. So, but when it comes to tax planning, it's about raising the amount of competition, your competition sphere on the marketplace. Because if you can engage in tax planning, you can better your competition, okay? Because you have more money to also buy your competitors and to engage in new projects. When it comes to law and liability, there are numerous of different areas of law who has various liability schemes. These, of course, will differ from country to countries and from region to region. And there are then some of them are looking into the voluntary creditors, involuntary creditors, and what on a good side, I would say that we see a trend to moving in the sense of tort law and contract law. We see a shift for some countries, particularly France and Switzerland now, who have made a liability regime for all social and environmental claims, where it's just cutting through the corporate structure. They're no longer looking into the complexity of the structure, which is often has been the problem. They're just saying that if we can link you to a contract, to a supply chain of your subsidiary further or on the lower level, then we will hold you accountable. So the parent companies, if you are situated, if you have a parent company or a subsidiary in France or Switzerland, now you're fully liable for any social liabilities or claims that can come from throughout the world. So this is legislative amendments which came last year. So for now we don't know how the courts will deal with this, but we see a push. Similar as what has been known as foreign direct liability cases, where the courts around the globe, typically in countries where parent companies are registered, they're starting to hear cases where, for example, for injuries of employees, for example, in South Africa was the case, parent company in the UK. Previously, we would say that international private law would demand the court to say, we don't have the closest connection to this case, we cannot hear it. But now we see a shift that courts are actually taking up more and more, in a way, responsibility, where we see that maybe our laws has not been able to step up. Liability regimes, the negative side is that these are very, very sector-oriented, meaning that they are not corresponding necessarily with each other. One of the findings in my own research shows that what we have tried to fix after the financial crisis in terms of disclosure of financial instruments can very easily be disrupted because they are resting upon a concept in corporate law which is not fixed. Accounting standards, what you should include in your accounts. So unfortunately, there is no coherent regulation when it comes to enforcement and liability. I will end with, in the terms of in tax law, where there has been several attempts to, and also ongoing debates on this tech tax and consolidated tax basis and information, OECD's information agreements and all of these. In my opinion, they all have severe weaknesses and limitations. So what is promising is maybe, or the most promising, I would say, is what we see happening in competition law for these sweetheart deals that companies are doing with different countries. And the reason for why this can be approached in the EU is because it's said to be then the states are supporting one company based on the competition regulations. It's not creating a playing field. It's actually disrupting the competition. But it should be in your mind that the legislation that you're looking into, if you want to understand where we can go forward with these issues, is not necessarily only in tax. If you look into corporate taxation, it's very much what's happening in other fields of law. So we'll end with my slide here. We need to understand the decoupled reality if we want to understand the whole. Thank you.
Thank you so much. I guess some of us would need some time to let it all sink in, because this is, for me, from journalism, heavy stuff. But luckily, I know that in the audience, we do have some really competent people. So we expect a few questions. The floor is open. We have 10 minutes. I can already see 2 or 3 hands. And as always, we begin with those who have not asked questions yet. Please also introduce yourself.
Hi, my name is Peter Ringstad. I'm with Tax Justice Network in Norway. Thank you, Linn, for excellent presentation. As always, you managed to sort of confuse our minds about the nature of international business. I've luckily heard you a couple of times before, so I can start by asking some difficult questions. You're sort of directing this to regulators and to civil society and people who want to change the system sort of from the outside, but I've been thinking a little bit about some unlikely sort of allies in this cleaning up the complexity that I would want you to comment on. One is banks are usually needed in transactions also within large company groups, and they are increasingly being put under strict regulation, particularly on anti-money laundering. And the new legislation on anti-money laundering coming in Europe is expanding sort of what is it that they are trying to pick up. So not just criminal activity or drugs or things like that, but also actually tax evasion, which is a huge complex problem for the banks to try to understand. But and they are actually put in a difficult situation when their customers are companies who put up these very complex structures because they don't know the nature of the transactions that they will provide for them, and they could be liable under the anti-money laundering legislation. So could we see a push for less complexity from sort of bank and finance institutions? Unlikely, but I'm just putting the questions up. Also, there's a asymmetry in information between investors, shareholders, and the company officers who are actually running the companies. And today, if we have a big stock-listed company, usually the largest shareholder has something like 2% of ownership. So there's sort of the investor sphere have big problems of actually controlling the companies. And the more complex the multinational company is, the less information and the more risk is actually put on the shareholders and the investors, who usually maybe are even a pension fund. So sorry, this is like a comment disguised as a question, but I just wanted to ask you whether you could comment on shareholder action in this information asymmetry.
Okay, thank you. Perhaps you'd like to answer to that question disguised as a question.
Thank you, Peter. Thank you for excellent questions. Okay, so first to the banks, the role of the banks. Absolutely. I think banks, the intermediaries, not only the banks, it should definitely also be included, the trust and company service providers, were also included in the money laundering directives, as you know. So banks are only one of the facilitators of these financial flows. Actually, I was writing a feature article in the aftermath of the Panama Papers, asking, well, the question was, who has made this possible? And I would say that the criminal activity, the companies or the individual beings who want to engage in criminal activity, they will always be there. But what we can address is the person, the people, the companies who are facilitating this. So then we have to approach the intermediaries much more than maybe has been addressed so far. And in the money laundering directive, they have now also decided to expand on the liability, what kind of investigation they have to look into. But I would say that a crucial problem with the directive is that the lawyer, if it's the lawyer, not the bank, it's the lawyer who facilitates, they are covered by legal privileges the moment they have signed a contract with their client. And very seldomly, and this goes, so the money laundering directive is only, in a way, functioning to its full extent if someone comes to me and saying that, I want to do some money laundering, can you help me? And I will say, yeah, I'll do. That will never happen. So, and again, when will banks know that they are a part of a tax avoidance regime or money laundering? And another, in that regard, what is very seldomly discussed is the chains of intermediaries. I have a very nice slide of that which I've used before. A report from the OECD a couple of years ago showed the length of the chains of intermediaries, meaning that the intermediaries will guard themselves by only knowing parts of the puzzle. So this is the same as corporations doing, you know? So they will say that we only knew about this transaction. How on earth could we know that if you put it together with this and this and this, it starts to look like money laundering? So this is also why we need to look into the intermediary networks, not only the corporate networks. Banks, they are heavily interconnected. If it's one thing that the financial crisis showed, it must be that, how interconnected banks are. And it shouldn't come as any surprise if you look into banking activity as its function, intra-loans and all of these things. It should be very straightforward, actually. But this goes similar to when it comes to their liability being expanded. How will they structure their business? They're in it for the money themselves. So it's not only the corporations, it's equally the intermediaries. And we're moving into more and more like, we're talking about here, like collaborating. It's the same. So maybe I will say that is the way to go forward, that we should look into that the liability of the intermediaries should be much more based on also the networks and which arguments that we will be buying when they can exclude or limit their own knowledge of a whole scheme. When it comes to investor sphere or shareholder activity, what has happened, if you look at this in a historical perspective, is that the shareholder mass has changed dramatically. So from what happened when we started to say that corporations could hold shares in another company in beginning of the 19th century, then when we see that nowadays it's much more the institutional investors who has, from the 1980s at least, been maybe changing the sphere the most. And the problem there is that they can have in their mandate that they will not do any active controlling voting policies. They will very often use proxy advisors from the US who has this ticking the box activity of what they think that an institutional investor should vote. And I've talked also to several funds, and they're saying that basically they're following those advice because they're into so many companies, so they actually could not figure out what they should vote anyway. But they can tell their investors that they have voted. So a lot of things going on there. When When it comes to the institutional investors, yes, you may be aware of, is that in the Shareholder Rights Directive in the EU, the amended one, they have now included an obligation for institutional investors to disclose their investment policies so that other investors could better position themselves based on their policies. But I would say probably that will not change so much anyway. We have to then look into how the ISS, the institutional shareholder something, the biggest one, largest proxy advisors in the US, how their policy is when they are giving advices. Because I don't think the institutional investors themselves will give anything else than great policy documents if it comes to voting, how they will vote their companies. In that regard, I just have to finish up with that even though our own, the oil fund, as we call it here, has a policy that they will be an active shareholder and vote in the companies they're in. If you look into the accounts of the oil fund, you will see that they lend out, they're doing decoupling en masse. So they're lending out a lot of the shares that we have invested in, meaning that we earn money on someone else voting the shares for the oil fund. And I would say that that's not necessarily how most of us would say that you're an active investor, especially if it comes to voting policy.
If you promise to be really short, I will let the last person ask a question. Okay?
Hi, my name is Petter Slottem Titland. I'm from Attack in Norway and also participating in Roy's course here. Just two short questions. Can you just explain briefly what blockchain ownership, how it works? And then...
Very quickly?
Yes. And then the contractual ties you talk about. How do we get access to them? And is it possible to disclose them in any way and follow the traces there?
Thank you. Again, two excellent questions. Okay, so when I'm referring to blockchain, that is something which is like ongoing. This is what's happening now. It has already gained its own abbreviation in the tech language, which is called DAOCs, Decentralized Autonomous Companies, meaning that instead of holding, what you want in a corporate group structure is that you're controlling the entities. As I said, very, very simplistically, you used to produce a car in one company. Now you don't want to hold all of the risk in one company, so you decouple it into 10 entities. If you go bankrupt in the corporations producing the ties, then it's not affecting the rest of the business. Put it very simple. This is like the whole legal privilege of limited liability for shareholders. Okay, so but you still want to control it because you're still going to produce that car. So you want to have full control. But as long as you have shareholding between the companies, then you have a lot of reporting obligations, a lot of costs, these things. In blockchains, which has so far been mostly discussed as a matter of, okay, it's the facilitator of cryptocurrencies, but it can equally be, it's a contractual platform where you have participants, which could be a company, which is a company in the decentralized autonomous companies, where all information is distributed amongst the participants. But it's a closed platform. You can choose to have it open. You can be Airbnb, you can be Wikipedia, you can do blockchain technology being completely open. But you can also choose to do it closed. And this is where our regulators and the authorities who are going to scrutinize these platforms have massive problems. Because for today, there is no reporting disclosure obligation for telling that you're a part of a blockchain network. But the interesting part of that is that if you have a corporate group where also with contractual ties, in the terms of legal language, we'll say that they are often imperfect contracts because they can be manipulated, they can be very biased, and there are a massive amount of information asymmetry amongst the participants. The perfect thing about a blockchain is that we have all of a sudden perfect contracts, because the thing of the regime is that it cannot be the information which flows amongst the participants cannot be manipulated. So that is like the whole thing, and which is why some people will say that for today it's hacker-proof. I would say that's maybe only a matter of time, but you will have then perfect contracts amongst the participants, which is the interesting part of that. But you will be under no disclosure obligation, and even though if you are a huge network, you will not trigger the disclosure of costly, very, very costly consolidated accounts, social environmental accounts, all of these things. So that's very interesting. When it comes to disclosure of contracts as such, it's contracts that are based on freedom of, it's like freedom of contract. You can do a contract with whomever you want. So this goes for you, it goes for a corporation. Corporation has the same rights, abilities to contract. So unless it's directly covered by legislation, it's not. But you can say that when it comes to financial accounts, it's the corporations themselves that should assess whether we have control over another entity, which means that they should also then assess all contractual ties. If that means that they have control, but the financial accounting standards degree of control is that you have an influence on your return. So if it's not a link between influence and return, then there's no control. So this is the problem, and this is also why, as I had where they had the circle of the part of the structure, that very much of the corporate activity may be left, or the economic activity may be left outside of the traditional disclosure regimes as we know it for today. This was why we have to look where it's coming around us and from behind, and not only still focusing on what we already know and what we already see. It's not working.
Okay, so thank you very much. Excellent presentation.